And welcome back. This is the first segment of our show this morning. As promised, we have been joined on the set by Lisa Shoman, attorney and former Foreign Minister of Belize. Good morning.
Good morning.
Good morning.
We're discussing legal opinions this morning, Marlene,
Yes.
as it relates to the ICJ and whether or not we should take our age-old territorial dispute for resolution at that World Court, correct?
And whether we should have a referendum any
Yes.
at all.
Yes.
Today I have my lawyer hat firmly on. Good morning.
Good morning.
I'm not this morning being an activist. I never know what that means anyway. But yes, the lawyer hat is on. And so I think we're going to look at two legal opinions this morning. One more in depth. The other one, which Marlene mentioned earlier on, is the legal opinion which was distributed over the weekend, because of course we can't wait for nothing, over the weekend from Professor Stephen Vassiani of the University of the West Indies. Now let me say from the outset that this is someone who I know, I respect very much, and I had absolutely no concerns whatsoever when Professor Vassiani was asked and tasked by my bar association to emit a legal opinion on a couple of things. One was the previous legal opinions that we had gotten, because there were those who felt that the 2001 legal opinion given by what I call the Magnificent Four was outdated, and also people who wanted perspectives on what had happened since 2004 to now, and how does it affect or not affect our claim going forward to the court.
Can I ask a question before we get into the meat of it all?
Yes.
It's something that I've pondered for quite some time.
Right.
In a matter such as this, does a legal opinion change? Does
No,
if you
not
have an argument,
unless
does it not remain the same?
It remains the same unless there is a fundamental shift in the underlying fact pattern. What do I mean by that? One of the things that Professor Vassiani cautions is that he says quite at the end that he hopes that we have scoured the archives, right? Because if there was ever a document to turn up that controverted our case, obviously, that would change the underpinning. But he says that to say, you know, I know you've done extensive work, so I really hope we're not gone through this. So we can start up by saying that there has been more than 60 years of scouring the archives in England, in Spain, in Guatemala, in Belize, even in the United States, to make sure that we've got every scrap of paper relating to this. So you asked me what would change. That would change, okay? So things like the unfortunate statements that have been made by certain foreign ministers of Belize, one in particular, are not going to change the fact pattern, are not going to have an impact.
Does it matter who commissions the legal opinion?
It doesn't matter. A lawyer will always give an impartial legal opinion. So once you've been asked to give an independent legal opinion, that's what it is. And Vassiani was at pains at the beginning of it to establish what his charge was, and his charge was to give an independent legal opinion. Your reputation as a lawyer rests on this, so no lawyer that values their integrity will give a legal opinion that is blatantly favorable to the client without there being excessively good reason for it.
Okay, we're jumping far into the conversation, and I wanted to kind of set the backdrop here just to say that there have been two recent legal opinions that we can speak of. The joint legal opinion, which was released, I think, about 2 weeks ago. And the recent legal opinion by Vassiani, which came out last week. Right. And just
came out on Friday, to be precise.
Yes. And of course, just to put it into context, because that's why I was asking about who commissions what opinion. Guatemala has had legal opinions on this as well.
And we've had sight of two of them.
The Hudson Report.
The one by Omanley Hudson, and another one, I cannot remember his name, but yes, we've seen both. I almost want to tell you it's Bianchi.
Okay. Yeah. And talking about the difference in the legal, because, you know, for most of us, the understanding of court is essentially two lawyers having different interpretations on one thing.
That's how it works. And you advocate for one side or another side, and you point out what are the favorable aspects of your case and what are the weaknesses of your opponent's case. And of course, your opponent does the same.
So if we're going to talk about the issues in our most legal opinions, can you at least enlighten us as to what have been the main differences between the legal opinions coming out from Guatemala and the legal opinions we previously used in Belize?
This is just it. What is striking are not the differences, are the points of concurrence. Basically, there is no contention as to what are the sources of law at the ICJ. And Vassiani goes through that painstakingly. And he not only goes through the sources, he goes through the relative weight or the hierarchical order of these sources. So I would say to everybody, if there is one document you want to read, since you want the latest, go and read Vassiani. But read Vassiani with an open mind. Vassiani absolutely confirms every single aspect of every legal opinion we have ever obtained. Plus, he also was at pains to go and look at Oman, Lee Hudson, and Bianchi. And he cites both of them in this legal opinion. So if you want one thing that gather everything up and cite it, this is it. And this is also the most carefully conservative opinion because it is written by a preeminent academic. Academics tend to be more conservative in their conclusions than, for instance, an advocate. So our Magnificent Four, who Vassiani praises by saying, these are some of the greatest advocates that have ever argued before the ICJ, which is Lauterpacht, Schwebel, Orrego Vicuña, and Shabtai Rosen. And he says these guys are like, you want a dream team? This is it. He doesn't use those words, but what he says is, these are the guys. And then there was also a previous legal opinion by Lauterpacht and Bowett, and he also cites that. He also clearly was at pains to go through the other things. And that notwithstanding, goes into the original material himself to give an assessment. So
there were a couple of things I found interesting, since it seems that we'll start off with Vassiani before we move into the joint legal opinion by our Belizean attorneys.
Yes.
So what's interesting is the outline that was commissioned by the Bar Association. Correct. And so it was looking for a legal opinion. It was asking also...
An independent legal... In other words, not tell me what we want here.
Looking for weaknesses in the Belize case.
Strengths and weaknesses.
Strengths and weaknesses, but also a very specific portion looking at the activity taking place in the Sarstoon, which is new. We don't have that anywhere else.
Not
in terms of a legal opinion.
There is one more thing that he commented on that is quite extensive, because it is a case that just concluded, the Chagos Island case, which, although it is advisory in nature, will obviously be highly persuasive and is entirely in our favor, because the court for the first time makes a definitive statement as such on the nature of self-determination as a principle of international law. And so Vassiani goes through that and goes through at pains what it means for Belize. And what it has done is to add an extra weight to our case. The excellent case that we had already had in 2001 is now strongly bolstered by this extra weight of self-determination. So he does an extremely good job of that.
What I appreciate...
And if you read nothing else, like I said this, because we don't know people where all the time like read what it comes out to, which is essentially 38, 39 pages of legal opinion. The total opinion is 48 in all. But some of it is bibliography, some of it is introduction. The meat of the matter is about 38, 39 pages. Read the last 2 pages, starting with the section that says conclusion.
Yes.
Very, very, very important, from chapter 55 up to, and they're not short chapters, but they are readable, chapter 58. 55 to 58, read that.
So let me just start off by saying, I think you are aware that for those who are pushing for a no position, this opinion has already been dismissed.
Well, of course, because I don't quite comprehend why it should be so, but we seem to be in a hurry to dismiss any opinion that says that we're going to win our case at the ICJ, or even any opinion that is strongly supportive of going to the ICJ. Now, here's the thing. Hold on. There's two kinds of no to the ICJ people. There's hell no, I won't go, I don't care what anybody says. And there are the ones who say, not right now, we're not ready yet. Okay? For the people who say, hell no, I won't go, I don't care what it says, it doesn't matter who gives a legal opinion. They will never accept that.
Their mind has been made up.
Correct. For the people who say, not now, we're not ready, it's not a matter of the legal opinion. It's a matter of the peripheral issues, whatever you call them. The electoral rules are not ready. We should get a Sarstoon protocol. We need to amend the Maritime Areas Act. We should put it in a deep freeze for 25 years. There are various reasons.
It included an updated legal opinion and also hearing directly
Good.
from...
So we've gotten
and hearing directly from our legal team as well.
Not only that, one more thing. There are those who say, yeah, we shouldn't go until we get an advisory opinion. And by the way, Vassiani tackles that very frontally by saying, okay, so what about this thing that you could go for a legal opinion? What it says is basically, if you go on a full case, and you know you're going on a full case that is writing, you're no business for the go for no legal advisory opinion. The court is not there for that. The court is not there for make you try out your thing.
Yeah.
Clear.
Yeah.
Very clear. Okay, so read it. It's in there in his words. I am not going to try to paraphrase him, but essentially, that is the heart of what he says.
Let me ask
so
you
for those people who don't want to hear, because I have come to understand that it doesn't matter what you say to certain people, if you aren't confirming their own deeply held belief, they won't listen.
Can I just say,
and
though,
those
I think that's
I
happening
have
on both sides, though.
Yes,
because similarly, the joint legal opinion by our Belizean attorneys has been dismissed by the Yes campaign as well.
And that is a different issue. So let's get to that in a few. I promise to ventilate that fully.
I have a layman question to ask nonetheless. We have all these legal opinions that are coming forward now. My question is, do you believe that the masses of people out there who will be participating in this vote on April 10th will either understand what is being said in these documents enough to be able to inform or persuade them one way or another?
I don't know. And that is the straight answer. I do not know. It will be up to each and every single individual to take the time. The material is out there. If you want the information, it's out there. Last night, I was at a village meeting in Guinea Grass. It was about 60 people. We stayed overtime. People asked questions, and at the end of it, people asked us to come back at another time when they thought they could bring out more people in the village to come and listen. Whenever I have had the opportunity to talk to people, whether it is a church group, whether it is a school group, whether it is a group from a village, whether it is a group from a town, whether it is an organization. On Friday, I spoke to the PSU. One thing I don't do, Isani, unless I am asked point blank, is I don't tell people what I am going to vote. I say to people, it's your responsibility to get the information. I hear you that you say government has to educate you, but that's a two-way street, because people will immediately say, when the government, they educate me, that's biased.
Okay, but can I just be clear? Whether or not you state your position at a presentation, it is
people
publicly
know it,
known.
And I know shy away from that. And if I am asked, are you biased? I would say, yes, I am biased. And I am biased not because I am saying yes. I'm biased because I've been in this process since 1999. This is not now. I'm a lawyer of 30 years standing, and for the last 15 to 18 years, I have been deeply, intimately involved in what we're doing. So let us not pretend that I don't have a bias. I have a bias from inside the belly of the beast. But here is the thing. Doesn't that have a value too? It has a value to have somebody who has been on the inside. I will tell you this. If I was the person making decisions for my nation, I would immediately ask Professor Stephen Vassiani to be our expert, our legal expert on our team, because I find him very fair-minded and balanced, and in a way he counterbalances some of the enthusiasm that people like me bring. In fact, he cites Assad Shoman. He cites Assad.
Lisa, let me just get into some of what the report says, because I think what was interesting was how, and he even explains what it seems to me as I interpret it, is that he isn't necessarily, he doesn't see certain points as a weakness, but he dives into them.
Yes.
To be absolutely fair.
Correct.
In looking at the credibility of some of these issues. That is the point.
So may I ask you this, did you find it readable?
For the most part, yes. Some of the Latin terms you still have to research, and I think that's understandable when you're talking about law. But for the most part, I think people can be able to comprehend.
Okay, so let me ask you this. Anybody who's had a high school education, read and understand?
I can't answer for anyone else, but I want to go back into what it says about, because we have to dissect, or I want to be able to dissect as much as we can as to what came out of the opinion. And the first one is, which the Yes campaign keeps on pushing as the main ace card for us, which is the 1859 treaty, which our No campaign looks at and says, well, that Cart Road and sea access was not addressed, and so we have a problem. So I want to talk about what the legal opinion says in terms of putting the 1859 treaty, and specifically Article 7, into perspective.
Yes, and remember that he first starts out by going through the hierarchical order of sources of law.
Yes.
Treaties are the first.
Yes.
Treaties are the first. And treaties are a very special type of contract. Now, one of the first things he says is look at what kind of treaty this is. And he makes the point very forcefully that there are extremely strong arguments, because you're not going to go further than that, for saying that this is not a treaty of cession. It is a treaty to define a boundary. And if you would explain
what a treaty of cession is.
Treaty of cession means agiopisalan. This was not agiopisalan. The words of Article 1 make it very, very, very clear that this was a treaty defining the boundaries, saying what the boundaries, recognizing what these boundaries were, and stating that they go back to 1850. And in fact, as you know, we go beyond even that. We go to the settlement and the expansion of the settlement. I had a lovely older gentleman in Guinea Grass yesterday giving me a history lesson about how people came here, what they came for, how they expanded. And he went all into going up to the Sibun and that particular Treaty of Versailles. And I was blown away by his grasp of history. This is a gentleman who must have been about almost 90 years old. So Vassiani goes into that. Then he says, look at Article 7 very, very carefully. He makes the point, first of all, that Article 1 has plain language that should be taken to be interpreted in that manner. And it never says that Article 1 is subject to Article 7. And it could have, and it didn't.
Here it is.
Correct. Never, ever says it, okay? It's not a quid pro quo. Article 7 is standalone and separate. So in other words, it doesn't say we agree to this unless this is... We not agree on 1 without you do 7. It never says that, okay? So Article 1 was not in exchange for Article 7. Article 7 was something completely different. He also makes the point that if you're going to rely on Article 7 or the non-compliance in Article 7 as a means of blowing up the 1859 treaty, the language has to be extremely specific. And this language, he says, is vague. Because if you say use your best conjoint efforts to work together and do the best we could for do A or B, the fact that you have not done it, no matter how it was not done or why it was not done, does not ipso facto, does not in and of itself mean that now the entire treaty gets to be set aside. And he says, even if you argued that, you cannot get past the point that once established, the treaty took on a life, the boundary established by the treaty took on a life of its own.
That's one of the interesting...
And then there were 60 years before we heard a peep out of Guatemala as regards to that particular boundary.
And this is something we've heard before in terms of how long it took, essentially, for an objection to be made that the Cart Road wasn't established, so the 1859 treaty is no longer valid.
60 years, and in between that time, the 1931 exchange of notes, which cemented the thing, occurred, and they didn't open their mouth at that time to say, yeah, well, if you don't build this cart road, we can blow up the whole thing. They never said that. And so they waited another period of time before they actually objected to this, right?
Now,
so I am constantly amazed by people who want to find reason to blow up the strongest legal arguments that we have. But this is one of the things that we contend with.
I have said time and time again right here on the show, I think the expectation for the mass public, not that they don't have the capacity to translate law from what we know as domestic law into international law, which are two different beings, is a challenge, and we have to sometimes look at it understanding the perspectives that people have.
Oh, I totally get it. I've said it time and time again that people's view of going to the ICJ is colored by the fact of how they have to deal with local magistrates' courts. I've said that.
Yeah.
I recognize that. I understand that.
That is what creates that apprehension.
I get it. I totally get it. But what this is saying, what other experts are saying, not me. I don't call myself an expert in international law, okay? I did have the opportunity to study law of the sea with the person who negotiated on behalf of the Caribbean, Professor Ralph Carnegie, and I was his only student for a year. And he understood that my purpose for taking the class was because of Belize, Guatemala, so everything we did focused as much as possible on that. However, I am not an expert in this field, neither is any Belizean attorney. The closest we have...
Do you understand then that people will hear you say that and say, well, if you don't study this law, then how can you speak on it?
No, listen to me. I am not saying this. Vassiani is saying this. What I am saying to you is you don't have to listen to me. I get it. Listen to Vassiani. What are you going to come with? Because you already said that people are already dismissing Vassiani. I mean, where else do you want to go? We've gone to the Magnificent Four, right? We've gone to the sources that Guatemala got its opinions from. You're still dismissing that. We've now gone to the most preeminent Caribbean person alive, and he's given an opinion. At what point do you allow yourself to believe? Because it's about trust, you know.
And
I
trust,
get it.
I love
get
that you
it.
say
It's
that
about
because
trust.
there are some people who want to put their trust, you talk of the Magnificent Four, into the Belizean Three.
I get you. I hear you. However, when you said the Belizean Three, who do you mean?
Musa.
Our recent joint
Sylvestre,
legal opinion.
Bradley.
Okay. Two different things. So let us please be very careful. There is an issue as to what our legal case before the ICJ would be. That's one. The Magnificent Three, as you put it.
I said the Belizean Three.
The Belizean Three, sorry. The Belizean Three is about whether we should or could go to a referendum. Not the same thing. Apples and oranges, and I will explain why in a little while.
We'll do that in our second segment, but I want to...
What is the point here is that if it is about trust and it is about faith, I understand that there will always be people like Thomas who want to put their finger in the wound. But at some point, given all the empirical evidence, all the evidence from lawyers, from writers, from academics, from former judges of the ICJ, because two of our Magnificent Four were former judges, all of them are telling us the exact same thing about our case. At heart, same thing.
What this legal opinion also brings to the forefront is the possibility of what the Guatemalan claim may be, which is a resounding question that we hear from people who have decided on a position.
He has a good section on that. He does.
And so I want you to be able to explain what it is saying in terms of what he perceives to be.
He says the same thing that the Magnificent Four actually says. It's just that the Magnificent Four say it in language.
I don't think we should call it Magnificent Four.
I
the
call
prior
it that.
Legal opinion.
No, I will call it that because they are magnificent and we need to understand who we deal with. I won't give them props. Demande that tapa tapa. No, sorry, I don't apologize for that. I hear you, but I will call them that.
Can I just say that we started this conversation with you saying not wanting to push an agenda, calling them magnificent four colors and creative. I'm saying they have their credibility as is. I just don't want anyone to feel
we won't argue about that. I have my view, you have your view.
So the prior legal opinion?
The legal opinion of 2001 says the exact same thing that this says about looking at what Guatemala's claim would be. Yes. The thing is, they don't say it in a manner that is as accessible. So what they say is that Guatemala will base its claim on inheriting rights from Spain upon independence. Their claim is that Belize was part of the department known as Verapaz. And Verapaz included Petén. And to their mind, Petén also included Belize. The point that Vassiani makes is that if you're going to make that kind of claim, there had better be some definite description of what it is that you inherited. And he is at pains to point out that there is no such description that is accurate, that includes Belize specifically, or even by implication as such. Guatemala cannot point to that. So that at the heart of their claim, is going to be a big gaping hole, which they will be called upon to fill. And up to now, every single legal study that we've gotten says they can't fill the hole.
And what he moves on to surmise is that perhaps the claim will be the Sarstoon, the Sibun to the Sarstoon.
Right. So now that goes into the second thing of the 1859 treaty not being fulfilled. Okay? And so that we've already discussed, what that is, okay? And what it amounts to. Basically, they say, you didn't give us the cart road, so therefore, we are going to assume that since we signed an agreement prior to 1859, giving you the rights of usufruct, meaning you're able to cut wood and this and that and the other. That was a recognition by Spain that Britain had the right to extract these things. It never said that it was administering that territory, but they rely on that, okay? And as I said to you, that in and of itself does not give Spain the right to say that they ever administered this territory. He goes through at pains to point out what is called effectivités in French, your effective control and administration. And he says,
which is what we use locally as occupation.
Correct. That's one of our strongest point. That's what the man say. This is one of our strongest points, in fact. Right? And what is even more amazing is the unique nature of our effectivités, because understand that this colony didn't start out as a colony. It started out as a settlement of free people. People coming here at first to extract logwood and then mahogany and then grow things and chicle extraction, what have you done through the ages. But don't forget your history. We started out on what was one of the first things the Baymen did, Burnaby's Code. What is Burnaby's Code but administration? You're imposing your law on this land. Okay? So that is very clear. And then all the acts that come after that. So he's really, really clear on that and as to what happens with that. So it's a beautiful thing to read, because if you bear your history in mind, you can see where his underpinnings are. And he's very fair about it as well.
No, I do agree with that much. And I think perhaps the Bar Association clearly outlined that they wanted the Guatemalan perspective to be included. We see where he makes an attempt to do so.
Absolutely.
Even,
yeah. And then he also goes into the thing of, well, let's say they're due some compensation. Who should that come from?
That's what I want to get into.
Who should that come from? And what he says is, if you have any claim for compensation, which he most decidedly does not say that they do, he says if they had any, it wouldn't be against Belize.
So
it would be against Great Britain.
That was one of the things that I made a note of, because we've heard people from the no camp, or people who are against going to the ICJ say this is not our problem. Give it back to the UK. Is that being validated in this opinion?
No, it's not. What it's saying is, what is the problem we have? The problem we have is that Guatemala refuses to recognize our borders and claims our country. Guatemala is not asking us for compensation. And we are saying, if that's your issue, which nobody has said that's the issue, if that's your issue, go check Great Britain. We don't got nothing to do with that. What we have to do is, what are we claiming this country and its present borders? Because you agreed to it not once but twice. And what we have done is, Assad is at pains to point out, which Vassiani kind of confirms here, which is to say, what do you inherit? You don't inherit the treaty, you inherit the rights under the treaty. And the boundary once created takes on a life of its own. And that's actually what we have inherited.
So what he says is, if there is a claim for compensation because of not fulfilling Article 7 in the 1859
and that's
treaty,
a very far if. Yeah.
But he acknowledges it, right? In trying to see the weaknesses and strengths of both sides.
Yes.
That would not be a problem for Belize. How do you differentiate for people to understand that the compensation or any challenge against
a promise, if I make you a promise, you can't look to Isani for that promise. That is as simple as it gets. Even if...
Okay, but if there's a part of that promise that says, this is where the line is drawn between us, how do you separate them?
I said it at the very beginning. One is not contingent on the other. Two of us have a piece of land that are side by side. I say to you, Marlene, with a quarrel over where the boundary line there, make we sign a piece of paper. And in that piece of paper, we will say, this is where the boundary line is. And we say, you know, we really should also make one path with a gate through the two-way fence so that I could pass from your land, forget to the road, and you could pass through my land, forget to the other road.
So I am
That's what we've said. Hold on. And then either I die or I sell the property to Isani. You do not have any issue with Isani because Isani has not made you a promise. You were relying on a promise with me, and neither is that promise contingent on the recognition of the boundary line. We never made it contingent. We never said this is the boundary subject to the fact that you and do this thing.
If you do this, you get that.
No. What we said is we and do our best for cut one thing through the fence and do this. And it moves on and you never say anything, and now comes along Isani, right? The line is established, the fence is there, or the boundary is there, whatever, the picado is there. And all of a sudden now you are telling Isani, so give me our money because we never do this fence. And the two of them is supposed to do it. Suppose Belize were to ask Guatemala for compensation for that. Then what? You see, we're not looking for that. We know that our case is based on the fact that you recognize the boundary, and that once it was recognized, the legal principle is it took on a life of its own.
So I'm listening carefully to what you have said, and while you put it forward that the if is a very far if between compensation, isn't it kind of easy to get lost?
You know why it's a far if? It's because Guatemala has never articulated that as being a remedy that they are seeking. They are not looking for compensation. They squarely on every occasion have said, we want a piece of property. We want something. We want something. Whether it is territorial, they've never said we want money that I know of. They've never said that. That goes back actually to one point in which there was a side treaty with England and Northern Ireland that was never signed by them. They were fighting a war with, it was signed by Britain, and at the time they were fighting a war with El Salvador, came back to it very late, I think a year and change later, and said, okay, we're ready for sign. And the British said, well, yeah, too late. You should have signed it. You had 6 months to sign it, you did nothing. Too late for you. At that point, they were saying, give it the money and we will build the road, right? That passed, and they said nothing more for another period of years. There's a principle in law called leches. You can't come way after the fact and seek to assert your rights. That's a basic fundamental principle, you know? So that's also at play, and that's a principle that's well known in domestic law. In fact, in domestic law, you have sometimes a statute of limitations that applies. I'm not saying that that applies in this case, but I'm saying the notion that any right you have is not simply open-ended until the end of time for you to assert is a strict legal principle, and you must abide by it.
Now let's move forward, because we spoke quite a bit about the 1859, and I want to talk about what it says, which is really the new information that we have on what is taking place in the SARS-2. Now, you know very clearly the arguments on both sides. In fact,
yes, I was involved.
One of your sticking
One of my
points,
things, yes.
that you wanted a SARS-2 protocol in place to have a stronger case.
No, to go to a referendum.
To go to a referendum.
As a protective measure.
Okay, so there is a call for a SARS-2 protocol. Some have hinged their no vote on the fact that there is no SARS-2 protocol and that the Guatemalans have been exerting force in
And what Vassiani says in a nutshell is, given what he knows and what he has researched and what he has been advised, has been the posture of Guatemala vis-a-vis the SARS-2 since, not forever, since 2015, which I have said all along. Is really only in 2015 that they started to act up with regards to the SARS-2. Vassiani accepts this as well, after having gone through the thing. And he says, everything that they have done, taken at its highest, has been responded to by Belize with notes of protest, diplomatic notes, and rejection. Even the simple fact of that activity which I attended in 2016 that was organized by the Belize Territorial Volunteers, Will Mahia, and that group, to whom I will always pay tribute for the simple act of citizens, not the government, citizens going on that SARS-2 to protest, that taken along with government notes, that, and I was in one of the boats that went around the SARS-2 island and was being bumped the whole way by a Guatemalan Armed Forces metal skiff. That simple act of protest provides us with the rejection of Guatemala's acts, and taken together with all of Belize's relentless notes of protest, even though some of us might think the language in it is weak, because they have a language of their own. They're not going to say, get off our river, suckers. Well, kind of work like that.
Here's a language
but what it says is enough to displace any idea that the Guatemalans have, that they are exercising effective occupation or control or anything like that, because I am tired of people saying that Guatemala has taken over the SARS-2. It most decidedly has not. We've resisted that.
Well, I do want to come back to that in just a second, just to clarify, because you have had a position on this issue, and you recognize that a SARS-2 protocol was most essential at one point in time.
It would have given not only me, but many other Belizeans an amount of comfort going into a referendum. Here comes Stephen Vassiani to say, you're worried about this? Here's the deal with that.
Well,
So, my worry was this. What happened if, while we are waiting for this referendum to occur, some really bad thing happens on the SARS-2? Do you know how negative that would be? That's one of the reasons I wanted a protocol, not because I believe that without a protocol we had a bad case. I never said that. What I said was, these are the things that we should have in place. However, when I said that, please recall, there was no date for a referendum being contemplated. What do you do when you're faced with the fact that a referendum will take place? You have to then decide to reassess your case and make decisions as to where you will go. I have done that. What I feel good about is that Professor Stephen Vassiani confirms what I have always known.
Well, he mentions, and you were talking about wording, protocol, which is I think key, because he talks about for the title to be acquired by prescription, Guatemala would need to establish that Belize has slept on its rights.
And we have never slept on our rights. He also says it would take a lot longer from 2015 to now for them to acquire any rights. So, make we forget about that.
So
and hold on, and he says one more thing. If you're going to try to establish that kind of right, you actually have to do it before any conflict arises. We all know exactly when our conflict arose. It arose when Guatemala said, rubbish the treaty, we no longer hold it. That is back in the 40s. So for them to now come lately, for try can't do anything,
It's
not a work.
Yeah.
My worry, Marlene, was what was going to happen on that river, potentially. What could happen if there was a confrontation during this time while we are waiting to go for a referendum.
Now, this is where
Thank goodness it hasn't happened.
Definition according to law is important.
It's
because
important.
as a Belizean, as Will Mejia perhaps would say,
Yes.
in fact, I shouldn't say anybody else, quote anybody else, but as any person who's ventured into the Sarsoon, any person who lives in that area and sees or experiences the continuous
pushback on a daily basis.
exertion of power in that area, and what many have classed as a non-response by Belize, that perhaps we are in fact sleeping on our rights
No,
there.
we are not. Vassiani points out very clearly why it is that we have not slept on our rights. And this is the beautiful thing about this legal opinion, that it deals with that and it explodes that assertion. I dare anybody to come and bring me the evidence. Bring me the evidence where you say that we've slept on our rights and we've done nothing, because Vassiani says exactly the opposite. He says, this is what you've done. Citizens have protested. Government has written diplomatic notes. You have never relinquished this river to the Guatemalans. They do not exercise effective control on occupation. Therefore, this is not a factor, and it has not occurred before the conflict, and it has not been long enough in scope or in time for it to be a factor in this case. So please, if you're not going to take it from me, and I accept that I am nobody for anybody to take anything from, by 30 years of being a lawyer notwithstanding, because so we go. Take it from Professor Stephen Vassiani, who is the preeminent Caribbean expert on this issue.
I wanna close off this review of this opinion by pointing out one thing. One of the main points being brought out by those who are pushing or who are against going to the ICJ, whether for now or at all, is the wording of the special agreement. And this legal opinion does not have any reference, any mention about what is becoming one of the more recurrent themes coming out from that.
He was not asked to do that. That was not a part of his brief. So now let's go to the opinion of the Belizean 3, which does look at that.
That we will do after the break. So we'll take a quick pause and we'll shift gears from the most recent legal opinion to that presented 2 weeks ago by 3 Belizean attorneys. That's coming up after the break.
When someone you love becomes a memory, the memory becomes a treasure. Channel 5 introduces the Daily Obituaries. The Daily Obituaries will broadcast all death and funeral announcements and memorials to honor your loved one's life and memories. The Daily Obituaries airs on Channel 5 prior to the evening newscast, with subsequent repeats at 10 p.m. and 12 noon the following day. It will also be placed online on our social media platforms, all for a standard package fee. Celebrate their lives and memories with Channel 5's Daily Obituaries. Honor in life and reverence in death.
Welcome back. We are switching gears to another part of the conversation that we've been having with attorney Lisa Shoman. And this time around we're going to be discussing and dissecting, of course, the legal opinion of, is it the Belizean 3?
The Belizean.
Yes, the joint legal opinion of my very esteemed brethren.
Yes.
Some of whom have been my in fact, all of whom have been co-counsel on cases with me. in one form or another.
Dickie Bradley, Kareem Musa, and Anthony Sylvestre. And as you clearly said earlier, and I do agree there has to be clarification, this joint legal opinion is not about the case in going to the ICE stages. Joint legal opinion is whether or not the special agreement is valid.
No, actually.
And
no, it's not
because of the special agreement not being taken to the House of Representatives.
All right, that yes. What it says is that the special agreement, that we should not be going to a referendum at this point because there are things that have not yet been done. And that those things include having the special agreement ratified in the House of Representatives and not merely the Senate. So that they say that ratification by the National Assembly is incomplete because it was only done by the Senate. And why do they say that? They say that the special agreement, the terms of the special agreement will operate as a partial transfer of the constitutional lawmaking power of the National Assembly to the ICJ. In other words, we are giving up our constitutional power. Why do they say that? Because they say that the special agreement impliedly amends, I'm reading directly, Section 1, 2, and Schedule 1 of the Constitution in a way that is not permitted, that is, that the special agreement is therefore unconstitutional and void in our national law, as the necessary legislative authority was not obtained prior to enacting the agreement nor since. In other words, they're saying it shall be gone to the entire National Assembly, not just the Senate.
And attain a 2/3
majority. Right. So that they say that the holding of the referendum will be unlawful and have no effect unless the necessary legislative authority is obtained prior to the referendum. Okay? So that, in a nutshell, is their argument. All right?
Now, you have spoken in part about this before when it was first released, and you've had more time to look at it now. And I want to hear, because they have not filed, they have not taken the case to the court.
I hear it's coming today.
They have said that they will do so.
I hear it will be filed today.
For the very simple fact, which was one of, which they've said that they've allowed for time for the government to correct where they feel that this special agreement has failed to fulfill the obligations of our constitutional law.
So stick a pin right there. You've heard the Prime Minister say that they have taken the step, the government has taken the step of obtaining a professional legal opinion on the matter, rather than just dismissing it or just having the AG's office look at it. My understanding is that that will be released this week. Okay?
Can I just stick up in there, because we can also include, I think, what we know what we understand to be the context here in Belize of how things function. And some people will view the Prime Minister's response to this joint legal opinion as a diversion of how he normally... Did you hear
what I said?
No,
the man is saying, I understand that whatever I say will have a political context, and therefore I am taking, because this is important.
Yes.
He said that. This is important. I'm paraphrasing his words now, because I listened very carefully when he spoke. This was at the
He did not dismiss it.
Correct, and he said that. I'm not going to dismiss it. Right? What I'm going to do is I'm going to get a professional legal opinion. My understanding is that this was done and that this will be released this week. Okay? So that's coming. I'm looking forward to it. In the meantime, with my 30 years of experience as a lawyer in Belize and with the last 15 years of working extensively with constitutional cases, including one of the most important cases that they cite here is the Veos case. This is a case that I personally took to the Privy Council, so I could tell you what I say. Kind of me argue it before the Privy Council. And I work with Anthony Sylvestre on this case. I've also had experience dealing with the Maya land rights case. I've had experience dealing with the Caleb Orozco case. I've had experience with other constitutional challenges. So I'm only giving you what my bona fides are, because sometimes we like say, well, you know about that, you bias. Adigio, my professional background. And part of the reason I was elevated to senior counsel had to do with my carriage of, in particular, the Veos case. So, yeah. In fact, the day when I went to Privy Council to argue, the Privy Councillors were told on that day that had I been in Belize, I would have been elevated. So immediately they addressed me as senior counsel. So it was that recognition. But that notwithstanding, my view of this case is that the legal opinion, first of all, shows an extensive amount of work. Secondly, however, it to me is in certain respects academic and of academic interest, and that I do not believe as a professional that any court will grant an injunction to prevent the holding of this referendum, first of all.
Why?
Because the conclusions on which they base their arguments are fundamentally not as strong as they say it is, and they would have to do much more. Let me give you a for instance. For instance, one of the things that they say is that the special agreement is in contravention of the description of Belize in Schedule 1. So let us go to what Schedule 1 says. The territory of Belize comprises the mainland of Belize and all its associated islands and keys within the area bounded by the frontiers with Guatemala and Mexico, and the outer limit of the territorial sea of Belize described as follows. A, the frontier with Guatemala is the line prescribed by the treaty between the United Kingdom and Guatemala, signed when? 30th of April, 1859. B has to do with the frontier with Mexico. And C has to do with the outer limit of the territorial sea is the limit provided by law measured from such baselines as may have been prescribed before Independence Day, which I'm sorry to tell you was 3 miles, right? However, thank goodness we passed the Maritime Areas Act. By law or otherwise as may be prescribed thereafter. It is that part, or otherwise as may be prescribed thereafter, would include any decision of the ICJ and does take into account the Maritime Areas Act. So, if you say going to the ICJ is going to contravene this, A, that is an academic argument because stated as it is, Schedule 1 makes it very clear that the base is the same thing we are going to go and argue at the ICJ, the 1859 treaty.
So the one final phrase in that particular article is where you find a flaw in their argument.
No. I am saying entire Schedule 1 makes it clear to me that it is speculative at best. At highest, it is an academic argument and will not be taken by any court, particularly at this stage. Because if you're saying that the special agreement, right, undermines
can I paraphrase
allows,
what they have articulated to us on the show?
Yeah.
That the special agreement allows for a potential change and goes against exactly what you just articulated. Because if Belizeans vote yes, it is a trigger of sorts to go to the International Court of Justice for a ruling that can potentially, because no one can say with certainty
depending
what will
on
happen.
what they say.
Yes.
Do you understand that's a lot of ifs? Do you understand how far an academic reach that is? You, for instance, are not arguing that this is what is going to happen or even that you fear that this would happen, although I'm waiting to see their witness statements because they're going to have to argue that to climb the constitutional hurdle. They're not just like that. And the fear has to be a real fear on the basis of something concrete. The Veos case, we went to argue. I fear that the government, since they put out a law, is going to put into place this preventative detention, and they're no longer giving us the option to go to a referendum to see whether we want it or not. By the time we got to the Privy Council, the government had pulled back on that. And you know what the court said? This is an academic argument, we won't rule on it. We won't rule on it. Yes, the government could bring it back at any time. Yes, you have an express fear that the government could bring it back at any time. But that's an academic argument and we simply won't rule. The ICJ will work in a similar fashion And a court here looking at this will say, if you are saying that this potentially could happen, I'm sorry, but that is much too academic for me to stop this referendum at this point.
Because of the ifs, the fact that
it has not happened, nor can you lay a basis for saying it will happen. And even if it did happen, my interpretation of Schedule 1, which I just read to you, is broad enough to encompass any decision that the ICJ will make.
Now, when you speak of it being an academic exercise,
yes,
you know, I really want people to be able to understand exactly what that means.
Okay,
because you're using it as a legal term.
Yes, I understand. What it means is that something will not happen yet, it maybe never happen, and you can't tell if it happen.
Yeah. Simple.
Now, yes, so, maybe so, kind of, and that maybe so kind of thing. Maybe so. Maybe. But the court will say, I'm sorry, but your maybe so is not enough for me to stop this referendum. That's point number one. Point number two, our Constitution decidedly calls for the ratification of treaties as going to the Senate. That was done. And nobody, including Advocate Kareem Musa, stood up and said, this is not enough. It has to go to the House. Bring it to the House now. In fact, let me do a private member's bill to bring it to the House. It may be futile, but I'm going to do it. I took motions to the Senate even when I knew they weren't going to succeed. You know why? Because it is a matter of principle.
But their point is that while that is how you validate any other treaty, one that has to do with our boundary definition has an additional requirement of the...
It doesn't. There's nowhere that says that. Nobody can point to me where it says that in our Constitution. And you cannot have it both ways. If you are going...
They cited that piece of
correct.
law.
If you're going by a strict interpretation of our Constitution, which they are, it says that nowhere. Nowhere does it say. And remember, you know, hold on. It does say that if you're going to deal with anything having to do with Belize, Guatemala, it must be taken to the people in a referendum. There's no such requirement for any treaty, such as the special agreement, to be taken to both houses. And the framers could at any point in our nation's history, 30 odd years, have amended this. Also, how is it that you're going to wait? Because this was signed in 2007. If this was so in 2007, it's been so all along. You said nothing from then until now.
Are you saying that that will have some weight in court as well?
How long
will it take to bring it?
Of course.
But they, you know, I asked, because we had Kareem and Anthony on the show, and I asked them why, in fact, they are deciding to take, or why they didn't take the cases yet after the legal opinion. And essentially they're saying they're allowing for time. Is it what you said before? In the Privy Council, you were told, well, you don't know what government's going to do if they were going to fix it, not fix it. And so they were using that very same point. That
from
we
2007 to now? No. I'm sorry. I don't accept that.
Too much time would have elapsed?
Too much. That is one of the things that any court, I think, will say. You understand? So I don't think that that is a determinative point. I do think it is an influential point. So there's a difference. I don't think that that alone will decide the thing. It do mean that the court won't take it into account. Okay? But for me, the starting point is this implied revocation of 1A and Schedule 1, which to me is not a practical point. In other words, it's academic. Now, maybe so. And B, the language in Schedule 1, the language is broad enough to accommodate any decision by the ICJ. One more thing, and this is of lesser importance, but I will say it for completeness. One more thing. Decisions by the ICJ trump whatever you have written in your national law. And we actually take care of that in the language of this law. We're careful. In other words, were a court to ever say a description that is not exactly in conformity with Schedule 1, it would have meant that Schedule 1 wasn't correct to begin with.
They have argued
that they don't touch that with a 10-foot pole. They no got it.
They have argued that the Constitution is the supreme law of the land.
Yes.
And if I'm listening to you, you're saying essentially then that whatever the ICJ rules.
No, I didn't say that.
Okay, can
you clarify that? The Constitution is the supreme law of the land, but where it comes to international law,
okay,
your domestic constitution does not trump international law. Okay. Because remember, at one point, Guatemala used to say, Belize es nuestro, and that was going to have no effect whatsoever when they got a court go argue. Similarly here, what we say in our constitution as being the description of our land is not going to be determinative. It is actually not even a source of law, except as a custom or except as proving administration. That is the way in which it would be. See?
Now, Lisa, you have worked with all three of these attorneys.
Yes, I have.
And I know they're more than just attorneys. There's a colleague.
Esteem and regard for them. I just happen to disagree with them on
to be absolutely fair.
Yes.
Where are the points that they make, or are there any points that they make that you think are strong?
No.
That can be held up in the court, that makes some sense to you?
Look, points make sense as an academic argument. What do I mean by that? I hear what you are saying, but this is not how the court is going to rule based on what you say. So I have utter respect for the fact of the work that they have done. Different lawyers will always have different interpretations on what something means or doesn't mean. I have looked at their authorities and I am satisfied that in my view, I either have a different view of the authority or I say the fact that the authority says A and I say it means B doesn't mean that the court will rule with you and not rule with me. In my opinion, as framed here, because I do not know what they're going to file today, in my opinion, this as argued in this joint legal opinion will not succeed in court. Could I be wrong? Absolutely, I could be wrong. Me said that openly. I'm looking forward to what the government expert is going to say because that's going to be important. That's going to be important. And I have no doubt that if taken to court, the state, which is represented by the Attorney General's ministry, because that's the way it's done in court, is going to come out with their own arguments as to what this amounts to.
Now we know very well that, and I think people understand this, that the courts rule based on what's happened before in the past. You know, that is a very important. Yeah. So that's part of what we look at. Is there any precedence for a case similar to this that we can take into consideration? Because Belize has only had 2 referendums.
Cited, yes.
And this is the first independent referendum that we are facing. I mean, separate from an election, I mean. And
it's not the first because we've also had a referendum on Belmopan. But I accept that that's a limited referendum.
Okay.
Yeah.
And this is the only referendum that we have had to go to.
It's certainly the only one with Belize, Guatemala.
Thank you. That's what I was getting to. So is there any precedence anywhere else that can validate this argument?
The one that they use, I don't think is applicable.
Which one do they use?
Brexit.
Yes.
The issue of Brexit in the UK. Now, one of the things...
And that's a Miller case.
Yes, but one of the things about Brexit is that the UK legal system... First of all, the UK doesn't have a written constitution. Let's start there. We do. First point of departure. So that the words in our written legal constitution have to be interpreted according to what the framers meant and what they believed they wanted to say. So I've said to you, there is nowhere here that says in our constitution that any referendum having to do with Belize, Guatemala has to be passed by both houses or any treaty. Number one. Number two, the Brexit issue also had to do with the fact that English legal systems were so intertwined with the European Union that to separate it wasn't a matter simply of just going through the motions. So that there are important points of departure in the precedent that they have chosen, and I think they are sufficiently important points of departure that a court will not rely on it in the same way that they do. A court will look at it and say this is interesting, but a court will take the differences and not the similarities, because every case is decided on its own particular facts. And that's what I wanted to clarify. So what I'm hearing from you is that because of the main difference between the Miller case, which was the ruling came after the Brexit vote, and then it did in fact say, and you know, some people said it was moot at that point because the decision was made, that in fact, but they might circle back to that just yet. So you never know. That they should have in fact taken it to Parliament. You know what is one of the principles of law that I have struggled to accept, but I've had to accept it? It is this: courts are exceedingly reluctant to interfere in political questions. Courts say our function is to interpret the law. Our function is not to interfere in a political process. Political processes are the purview of the executive and to a certain extent the legislature. Okay? That's not the court's purview. So there are many times when a court will say something is a political question. For instance, an election petition. You got to come good for make one court overturn one electoral decision. And I say I've struggled with it because I've taken those cases to court and I fought my way through. I fought my way through even things like the dual citizenship issue, and I lost. I lost, and I'm very clear as to why I lost. To my mind, this is not one of those situations. Could I be wrong? Sure, I could be wrong. But that's why I said to you, I am looking out for the legal opinion that the government has got, because I'm very curious to see if it's going to converge with what I'm saying or whether it will converge with what my brethren are saying. Okay. So we'll look out for that this week because it's coming, and I think it's going to be good. What I love more than anything is that we are actually dissecting the issues here. We know they call each other name. I want to make it abundantly clear that I have nothing but respect for Anthony Sylvestre, who I think very soon is going to be one of our leading senior counsel. I have maximum respect for Kareem Musa, who is not only eminent counsel, has won many cases, but is also an esteemed member of the House of Representatives. And I have respect for Dickie Bradley, who is the preeminent criminal attorney in this country, and who has in his bag of advocacy probably more tricks than I will ever have in my lifetime. And I say that with love and respect. So please, this is not a personal issue. I want to make that divide very clear. We can always agree to disagree without being disagreeable or personal. And I love that we are reaching this stage in our arguments having to do with the Belize Guatemala issue, the referendum, where we can discuss these things and discuss the issue and attack the issues, but not attack the persons associated with the issue. And we appreciate you coming in and sharing your opinion on the joint legal opinion and helping us to dissect what came out of the recent Vassiani opinion as well. Thank you. Thank you for your time. Before I finish, I want the Bar Association to bring Stephen Vassiani. I really do, because I feel, and they promised a forum. I hope Professor Vassiani will come. We're told that our legal experts will come. My fondest hope is that Professor Vassiani becomes one of our legal experts. And I look forward to Belizeans using the next 40 days, because it's going to be like Lent, the next 40 days to learn as much as you can. I have totally enjoyed my interaction with Belizeans. It continues. I imagine that the pace will become even more frenetic now. I'm looking forward to it. And I am accepting every invitation that I've been given as much as I can. And I know other people are doing the same. Read as much as you can, listen to as much as you can, and go into that referendum with an informed mind. Thank you very much for being here. Thank you. All right, we're going to go ahead and take a break. When we come back, we will be talking to representatives of the Belize Association of Planners, so stay tuned.